Imagine you've been dealing with a hostile work environment for months. Your manager has been making inappropriate comments, you've been passed over for promotions you clearly deserved, and one day they finally push you too far and you decide to take legal action. You hire a lawyer. The case looks strong. You have witnesses, you have dates, you have a clear pattern of behavior. Your attorney tells you this is a solid case. Then discovery starts. That's the phase of a lawsuit where both sides have to hand over evidence, and the company's lawyers send over a request for all text messages related to your employment. Your coworker, your friend, the person you vented to every single day has to comply. The court orders it. And suddenly, on a screen in a conference room, a lawyer is reading a text you sent 8 months ago. LOL, that's so wrong. Sent right after your manager made the inappropriate comment you're now suing over. Honestly, I've been job hunting for a while. I'm so over this place. Sent 3 months before you were forced to resign. Hey, can you just clock me in? I'm running 10 minutes late. Sent on a random Tuesday that had nothing to do with anything. Your strong case just fell apart, not because you were lying, not because the discrimination didn't happen, but because of text messages you forgot you sent to someone you trusted completely. What's up, everyone? It's Soluna. Welcome back to Soluna versus the System, the channel where we expose the traps that cost workers their jobs, their money, and their legal rights, so you can stop losing before you even know the game has started. Today, we are talking about 4 text messages you should never send to a coworker, what each one does legally, why even your closest work friend can't protect you once a lawsuit begins, and the one rule that will keep you protected no matter what. Quick disclaimer, nothing in this video is legal advice. This is education only. If you're dealing with a specific situation, please talk to an employment attorney in your state. Let's get into it. Text number 4, the awkward acknowledgement text. Here's the scenario. A coworker or supervisor texts you something completely inappropriate. Maybe it's a dirty joke. Maybe it's a comment about your personal life or your medical condition. It makes you deeply uncomfortable, but you have to see this person at the office tomorrow and you don't want to make things weird. So you send back a laughing emoji or a thumbs up or just LOL. That text just walked you straight into a legal trap called the unwelcome standard. Here's how it works. If this person continues harassing you or creates a hostile work environment and you eventually file a lawsuit, one of the things you have to prove is that their conduct was unwelcome. That's a legal requirement, and the company's lawyers are going to pull those text messages and say, look, they laughed, they sent emojis, they didn't ask them to stop, they welcomed the behavior. And here's the brutal truth. That defense can work. Courts have ruled in favor of employers based on exactly this kind of evidence. Your laugh emoji just became the thing that killed your harassment case. What to do instead? If you get an inappropriate text, the safest response is to say directly, I don't appreciate that. Short, clear, on the record. If you want to avoid confrontation entirely, don't respond at all. Silence is legally neutral. A laughing emoji is not. Text number 3, the I'm looking for another job text. You're frustrated, you're underpaid, you're being treated badly, so you text your work friend, honestly, I've been applying to other places, I need to get out of here. Seems harmless. Here's the legal problem. That text can destroy a specific legal claim called constructive discharge. This is the claim you make when you weren't technically fired, but the working conditions were so intolerable, so hostile, so unbearable that you were essentially forced to resign. Constructive discharge allows you to sue for wrongful termination, even though you were the one who walked out. But to win that claim, you have to prove your resignation was a desperate response to the abuse, not a calculated career move. If the employer finds a text from 3 months earlier where you said you were already job hunting for a better salary, your constructive discharge claim is gone. They'll argue you were planning to leave anyway, that your resignation was voluntary, that they didn't force you out. You were already on your way out the door. There's also a secondary trap here around mitigation of damages. If you texted a coworker that you turned down a job offer or that you were taking a break from your job search, the employer can use that to argue you didn't make enough effort to find new work. That directly reduces the amount of lost wages you can recover, even if you win your case. The rule? Your job search is your business. Keep it completely private until you have a signed offer letter and you're ready to give notice. Text number 2, the trash talk text. Bad day. Your manager micromanaged every move you made. They made a decision that made absolutely no sense. You're furious. So you text your coworker. I hate him. He's such an idiot. I genuinely cannot stand this man. We all need to vent. The problem is doing it in writing. Here's the legal mechanic behind this one. It's called burden shifting. If you sue your employer for discrimination or wrongful termination, the burden shifts to the employer to provide a legitimate, non-discriminatory reason for firing you. Often, they just make one up. They lie. They'll claim you had a terrible attitude, that you were disrespectful, that you were toxic to the team. Your lawyer's job is to prove that reason is a lie. In employment law, that lie is called pretext, a fake justification designed to cover the real illegal reason. But if the employer finds screenshots of you calling your manager names, you just made their lie look completely believable. They'll put that text on the screen and say, "We didn't fire this person for an illegal reason. We fired them because they were toxic and disrespectful. Here is the proof, right here in writing." You handed them the cover story. You made pretext look like truth. The rule? If you need to trash talk your boss, do it out loud, in person, with someone you trust. Never put it in writing. Ever. Text number 1, the bend the rules text. This is the most dangerous one on the list, and it's the one that feels the most innocent. "Hey, I'm running 10 minutes late. Can you just clock me in? I'm almost there. I forgot to sign the safety log. Can you just initial it for me real quick?" Small favors between friends. Happens all the time. Nobody thinks twice about it. But legally, you just documented a valid reason for your termination, and it triggers something called the Afteracquired evidence rule. Here's exactly how it works. Your employer fires you for an illegal reason, discrimination, wrongful termination, whatever it is. You hire a lawyer. The case is strong, but during the lawsuit, discovery happens. The company's lawyers get access to your text messages. They find the message where you asked your coworker to clock you in. Even though that text had absolutely nothing to do with why they fired you, they can now say, "Well, if we had known this employee was committing time card fraud, we would have fired them for that." Courts allow this. The After-Acquired Evidence rule lets employers use misconduct they discovered after the fact to limit your damages, cutting off your back pay, your front pay, your entire financial recovery. It effectively tells the court, this was a bad employee anyway, we would have fired them eventually. A text you sent on a random Tuesday just became the thing that erased your compensation. The rule: never put a policy violation in writing, not even a small one. Not even between friends. The rule that covers everything. Before we wrap up, I know exactly what you're thinking right now, but my coworker is my friend. They would never show those texts to my company. Here's what you need to understand about the legal process. Once a lawsuit is filed, both sides enter a phase called discovery. During discovery, the employer's lawyers can legally demand copies of all text messages relevant to your employment. It doesn't matter how close you and your coworker are. If the court orders those texts to be produced, they will be produced. Your coworker doesn't get to say no. The friendship doesn't protect you. Every joke, every complaint, every venting session you thought was private, all of it laid out on a conference table for lawyers to read. So here's the one rule that protects you from all 4 of these traps. Write every text to a coworker as if it will be projected on a screen in a courtroom. If that thought makes you uncomfortable, don't send it. Here's your recap. The 4 texts that can destroy your career and your legal case. Number 4, the awkward acknowledgement text. That laughing emoji just proved the harassment was welcome. Number 3, the job hunting text. You just killed your constructive discharge claim. Number 2, the trash talk text. You just gave the employer their cover story. Number 1, the bend the rules text. You just handed them a reason to fire you that courts will accept even after the fact. The system counts on you not knowing how any of this works. Now you do. Protect your income, protect your case, and treat every single text to a coworker like it's evidence, because one day it might be. If this video helped you, smash that like button and subscribe. We drop new content every single week on exactly this kind of stuff. And drop a comment below. Has a text message ever gotten you in trouble at work? Tell me what happened. I read every single one. See you in the next one.